Thank you, President. And you'll be getting used to my voice, I'm sure, and probably bored, mindless. This is going to be a very short reply. And again, I thank the government for their views, and I understand where they are coming from. Now, it must be stated that this amendment here is actually being brought because it's actually been 5 years since that review was created. And one part of that review, I'm going to read 8.4 of that review. I'm going to quote the Honourable Wayne Martin in that report. He says, "The most significant issue in my review of the Act and the submissions I have received is whether the court should have a general or more narrow discretion to direct that all or some part of property not be confiscated on the grounds that the confiscation is contrary to the public interest or the interests of justice." I've also had multiple communications from lawyers and indeed from judges who are asking basically for the freedom to do what needs to be done themselves. Because the impact of this law is that the judge, who is going to listen to both sides of what's going on, both lawyers' sides, the judge needs to be able to make a judgment of to what is actually going on. Whereas on the prosecution side, what they're basically saying is we're going to go for the maximum penalty. And then you can work it down, of course, but the maximum penalty, and we'll see where it goes. And in this case, the judge has no discretion. Now, any time we have a judge being refused the ability to make their own opinion about something, we actually have the risk that we're going to have a manifest injustice. And indeed, this is exactly what we have seen. We are not at all suggesting that the law would become weaker. No, not at all. The law could become stronger, in fact. What we're simply asking for is that the qualified people, the lawyers and the judges, be allowed to actually be lawyers and judges. This is a manifest injustice. Now, the review was from 2019, I think it was, and we've asked on a number of occasions why has no progress been made. And the answer is because, as the Leader of the House has pointed out, it's actually a very big bill, very complex. And so what I'm wondering is why has not even the start been made on working on it? The information I have is that not even a start has been made. And so, 5 years on, we are having, again, manifest injustice throughout our legal system, where people being confronted by this legislation are suffering, improperly suffering, unjustly suffering. And the system is now created such that there is no redress, there is no recourse, there is no ability to receive manifest justice, however that justice may fall out. And this is really all we're asking for. Now, if the whole bill, the complex bill, needs to be rewritten, that we will accept. But one part of it, one simple one, let's think of the Monty Python film with that last fine little after-dinner mint. Would that really cause this law to be burst? That little after-dinner mint of just allowing the judge to actually make their own opinion. Does that bring this law to an explosion? Does it really? Of course it does not. I can see very well why you'd want to defer things and make it all proper, much like the firearms legislation coming through. We're going to do the whole thing in one go. I can see where you're coming from. But if we find in a legislation that one part of the existing law is manifestly unjust, it's wise to fix that now, as, in fact, we have seen in multiple changes to the Misuse of Drugs Act over the course of this last 3 years of Parliament. Has happened already. This is not an exception. It's just not part of the changes that the government supports. So we've just, I think, 2 or 3 amendments to the Misuse of Drugs Act have gone through our House already in this term of Parliament. But this one hasn't. So the argument that we can't do this because we need to fix the whole in one go actually doesn't hold water. But I can see where you're coming from. And what I'm standing for here is that we consider this and that we do consider in the second reading that we allow justice to be applied by those who are permitted to dispense justice. Not that we've decided in advance, we'll take this to court, and you, Judge, have no choice, because I have decided, as the prosecutor, this is what you're going to do, and you don't have any choice in the matter anymore. You've got no say. This is manifestly unjust. And I would ask that all sides consider this very seriously, because it is not just a matter of one part of a law. It's a matter about applying justice to the people, serving the people. This is why we're here. And at the moment, we have a manifest injustice And I cannot stand here and leave that unaddressed. So I ask your indulgence that you understand where this is coming from. It is not about supporting cannabis at all. Not at all. It's about supporting justice. And in those words, I thank you and sit.
Members, the question is the bill be read a second time. All those of that opinion say aye. Aye. To the contrary say no. No. The noes have it. Members, that takes us to item 3, criminal confiscations under the Criminal Property Confiscation Act 2000. And the Honourable Brian Walker has moved that this House calls upon the Cook Labor Government to impose a moratorium on criminal confiscations under the provisions of the Criminal Property Confiscation Act 2000 until such time as the findings of the 2019 Martin report have been addressed, and the question is the motion be agreed. The Honourable Brian Walker.
Thank you, President. President, I move the motion in my name that this House calls upon the Cook Labor Government to impose a moratorium on criminal confiscations until the provisions of the Criminal Property Confiscation Act 2000, until such time as the findings of the 2019 Martin report have been addressed.
Members, the Honourable Brian Walker has moved that motion, and the question is the motion be agreed. The Honourable Brian Walker.
Thank you, President. Now, a lot of what I intend to say has already been said. In fact, it's been supported by the government already, that we all can agree that the Martin Report 2019 must be addressed. And we can also agree, I think, if you listen to my words and you find nothing objectionable in the fact that we want justice in our system, it'd be difficult to object to the concept that if a law is currently in force, if an act is currently in force, and as a result of enforcing that act, a manifest injustice is being caused, then it makes manifest sense that we ought to impose a moratorium on that particular part of legislation to allow for justice to take place. Now, I don't think that's very much. I do not believe that that is an object of contention. We all surely are going to support the concept that the legal system is there to ensure justice is being seen, is being done, that justice be applied equally to all. And when we discover laws which clearly do not meet that high standard, then we, as a body, as a parliament, are obliged, are we not, to either remove that law or to amend it or to rewrite it. This is one of our essential functions. Now we have, as I said earlier, in the Criminal Property Confiscation Act 2000, an eminent legal mind has given the very strong opinion that this law must be changed. And I'll say it again, just for the benefit of Hansard, quoting again. That the confiscation is contrary to the public interest or the interests of justice. The most significant issue in my review of the Act and the submissions that I've received is whether the court should have a general or more narrow discretion to direct that all or some part of property not be confiscated on the grounds that the confiscation is contrary to the public interest or on the grounds that it's to the interests, contrary to the interests of justice. That is a very serious statement. So what he's saying here is that the law as it currently stands is actually against the interests of society and against the interests of justice. Now, I would like very much to hear how someone could stand up to the Honourable Wayne Martin and give an adequate explanation of why he is wrong. One of the most eminent legal minds in our time. How can we then stand up and say, actually, you're wrong, mate. No, you got it wrong. All the information that's come into the committee, all of the examinations that have been done, this being the conclusion, we don't believe you, you're wrong. And so unless someone's prepared to do that with an equal legal eminence, then I think it's difficult to argue against the motion. Now, the motion has, however, been worded not to criticise the government. Not at all. This is my point of view that I have always stated that those who are working in this building, in this establishment, are of high standards, high moral standing, and are doing their best to serve the people of the state. I will always maintain that. And so I'm not going to tolerate the idea of shouting across the chamber and saying you're wrong, or you're bad, or you're doing horrible things. That doesn't serve the public interest. What I'm calling upon here is a moratorium on criminal confiscations under these particular provisions. And I'm not asking even for the law to be changed. It's just this particular part, let's call a bit of a halt. Let's say to the prosecutor, let's say to the judges, we're not going to actually work this particular part of the Act. Now, you could say we can't do that, but I then point out the Public Health Law of 2016 or 2018. There's a clause there which allows a police officer to strip you naked and to have you forcibly administered an injection of whatever against your will at the command of the police commissioner. Now, that's fairly tough stuff, isn't it? You can get stopped if you're identified by the commissioner of police. Now, we need to do something to you, and you can be stopped. And if you don't agree to it, they can actually stop you, strip you naked, and have you forcibly injected, hopefully by a doctor or someone who's medically trained, against your will. Now, you might then say, well, look, OK, this is just in the pandemic, and we've got to make sure that people are safe. OK. I've done that, actually, with patients myself who have been mentally ill. They've been forcibly under the care of the police, who are the only people allowed to do this, by the way, because I'm not allowed to use force on someone, but the police officer can. And they have been stopped, they have been forcibly undressed, at least all undressed, but they've been exposed, and I've then been enabled to inject that patient with something as an antipsychotic to calm them down from their rampage. They want to kill someone, they want to destroy the ED, they want to kill their partner because of a psychotic process. That's a very sensible law. But I need to fill in forms for that, forms Schedule 1 and 2, to allow the police officer to do that. So there's very strict controls. And when that person is now transferred to a psychiatrist, they need to examine again what's going on here, and just to be certain, is Dr. Walker behaving in the right way? Was this an appropriate action? Shall we reverse this, or shall this person remain as an involuntary patient until the psychosis has been treated? And when I questioned this in specific regards to, say, the pandemic, with the idea that you could be forcibly stopped, stripped and injected with an anti-COVID vaccine, I was told, and this is brought in, of course, by the Liberal government, I was told by colleagues on the Liberal side, said, oh, yeah, we're never going to enforce that. We brought that in, but we're never going to enforce that. So when I then said, well, if you were never intending to enforce that, why was it actually in the statute book anyhow? If we've got the permission to do that, and right now a police officer at direction under certain conditions can do that. It's in the books right now. This can happen at any stage, any time, legally. Why is it in the statute book? There's another case here. That's theoretical. I know it's never going to happen because it's just improper, but it's in the statute book. But there's a patient of mine a little while back who was sexually abused as a child and has PTSD and is actually really quite distraught. And I've said the story before. Her father was growing cannabis in the backyard because that was an effective cure, or treatment, not cure, treatment for her PTSD. She could actually exist without actually wanting to kill herself. And so the police discovered that, and he was arrested, and she was arrested. Now, bearing in mind, she was arrested for using cannabis that her father was giving her, growing in the backyard. She was then put in the back of a police car, alone. She was taken to a police station, and there, at the police station, a child of sexual abuse as a child with PTSD was strip searched. Now, I challenge anyone here to tell me that's going to help the PTSD in any way or form. Has harm been caused? It absolutely has. Is that person still suffering the trauma of that event? Yes, they are. How do I know? Well, I'm their doctor. Was it illegal? No. It was very much legal. We have permitted that. So the trauma of that person has been exacerbated because of us. We may not have passed that particular law, but we are in a position of power to change that, and we have not. What's that being said? Those who, the assault you walk past is the assault you tolerate. The offence you walk past and say nothing is the offence you tolerate. The abuse that we have created and walk past is also the abuse we tolerate. I ask you, members, do we really want to be that kind of person? And so the motion I'm putting forward here is basically this. Let us stop causing injustice. Let us stop permitting injustice. Let's put a moratorium forward such that justice can be seen to be done and that appropriate action can be taken to amend the laws which are causing injustice. It's a simple thing here, and I would anticipate that we would agree with the principle of not causing harm, would we not?